Yep. Hello, everyone, and welcome to another exciting live stream with immigrationquestion.com. As everyone knows, it's discouraging to spend years of hard work and effort in trying to improve your life, only to encounter major obstacles and have all your aspirations put on hold. This is the reality for most immigrants navigating the complex US immigration landscape. One mindstep or barrier can place a hold on the dreams and also hamper your future. But what if there is a way to come around this, and what is the past obstacles that we use to actually work around it? Today's topic, overcoming immigration barriers and understanding waiver applications, was created to uncover the many ways to waivers can turn impossible situations into new beginnings. My name once again is Kunal Bechu, and I'll be your host for the today's session. As you have loved and all loved ones has know that immigration question has been around for some time, and especially in immigration challenges due to the indemnifiability of different barriers. This session promises to answer you the promising questions to actually get this journey on the way. Joining us in today's session is a seasoned attorney. She has a strong background in family-based immigration, humanitarian immigration, asylum, U1 visas, as well as 601A waiver application. Based in San Diego, she is a dedicated in helping clients navigate the complex immigration challenges with compassion and expertise. Join me in welcoming attorney Christina Liao. We are thrilled to have you on today's session.
Thank you, Kunal. It's nice to be here.
It's a pleasure once again. To our audience streaming on various online platforms, it's about to get exciting. So grab your notepads and pens, and let's start to begin the session. Without taking any more time, let's jump into our today's topic. Attorney Liao, we know that the waivers have been around for a while, and given the recent global political shifts, the application process has been more complicated. Can we start off by explaining some of the waivers people might come across and what they generally cover?
Sure. So, when you're using the word waiver, you're essentially asking the immigration powers that be, DHS, DOJ, to forgive some sort of immigration infraction or some sort of immigration violation that you've made.
Mhm.
One of the rules of being able to get status in the United States is that you have to be admitted to the United States. So it's a pretty basic concept. If you're going to enter a country, you need the permission of that country's government for you to come in. And usually that's in the form of a visa that's pasted in your passport. If you don't have that, or if you did have that but you violated the terms of your visa, then either the US government would not admit you to the United States or they would revoke that admission. So when you use the term inadmissibility, it means that you've done something that would make the US government unwilling to admit you to the United States.
Mhm.
When you have an inadmissibility, what that results in is whatever immigration benefit you're going to apply for after that is going to be denied because the US government doesn't even want you here. And so they're obviously not going to give you the immigration benefit that you want. In that situation, if your immigration violation or infraction is forgivable, then you would submit the relevant waiver application where you're asking the US government to waive that inadmissibility or to forgive that inadmissibility. There are some immigration violations that you can forgive, and there are some that are not forgivable.
Mhm.
So, for example, making a false claim to US citizenship is the unforgivable offense in immigration world. But generally, that's what waivers do. Um, I think probably the most common types of waivers you would encounter would be an I-601A waiver. So that's the waiver for unlawful presence. If you enter the country without inspection or admission, either because you showed up without a visa and you somehow got ushered into the US, or you came in without any detection, you never encountered immigration officials, you can't prove that the US government allowed you to be here. So
Mhm.
your presence every day that you're in the United States after your entry is considered unlawful presence. If you've accrued unlawful presence that's 180 days or longer, so more than 6 months but less than a year, essentially,
Mhm.
the next time that you step foot outside of the US, you'll be barred from entering for 3 years. If you've accrued unlawful presence for more than a year, more than 365 days, then the next time you step foot out of the US, you're barred for 10 years. So if you're in a situation where you need to get status, you have a way to get status, and the only thing that's standing in your way is your unlawful presence, that's where you would get a 601A waiver. When you submit that, you're asking the US government to just forgive the unlawful presence, but everything else is fine. You meet all the other eligibility requirements. That's what that would be. Its very close cousin is the
Mhm.
I-601 waiver, which also forgives unlawful presence, but also forgives criminal infractions and other inadmissibilities. And then you have another kind of waiver called the I-212 waiver that has an even broader scope than that, which also forgives criminal infractions as well as other immigration violations. Um, I think it might be beyond the scope of our time for me to go
Mhm.
into everything that those waiver applications
Certainly.
forgive, but that's probably what most people will encounter.
Awesome. Thank you. And thanks again, Attorney Liao. So let's dive into the application process. Many people are often unsure what or when to start and what key steps in filling in the waiver application. Could you walk us through the essential steps for compiling a waiver application?
Sure. Fundamentally, even before you're thinking about seeking a waiver, if you're going to ask the US, so again, right, the waiver application is asking the US
Mhm.
government to forgive a violation that you've committed. Before you can ask the US government to do that, you have to prove to the US government that that forgiveness is for something. You have to have some other way of getting status or some other way of applying for an immigration benefit that the waiver will allow you to see to the end. So you can't just file the waiver application on its own without having another plan to do something. Um, so once you have that plan of what you want to do, the immigration benefit, the main immigration benefit that you're going after, then you decide what is the immigration violation that you need the US government to forgive, and then you talk to an experienced immigration attorney so you can figure out which one of those applications you need to file. Generally, for all of these application types, you need to prove hardship to
Mhm.
a US citizen or lawful permanent resident relative. So, for example, for the 601A, you have to prove that if you didn't get this waiver, and if you step foot outside of the US and you're barred for 10 years, um, your US citizen spouse or parent, or your LPR, lawful permanent resident spouse or parent, would suffer
Mhm.
extreme hardship. And that's the same standard for the 601 as well. So in this situation, it's going to sound a little cold, but the US government doesn't actually care about you. If you're a non citizen, the US government isn't that interested
Mhm.
in forgiving your immigration violations just because you asked them to. What they're interested in is helping your US citizen or LPR spouse or parent. So if you can prove that because of financial support that you've been giving your relative, or emotional support, or housing, or childcare, or whatever it is, in whatever ways that your absence would cause extreme hardship to your US citizen or LPR spouse or parent, um, all of that evidence would go
Mhm.
into a 601A waiver application, for example.
Awesome. That's some really great advice. Certainly, now another area that intersects with waivers is the humanitarian immigration. Right, we have seen waivers play a role in these cases involving asylum seekers, those under temporary protected status (TPS). Can you share a bit about how waivers connect with the humanitarian pathways?
Sure. Waivers generally, you don't generally see a lot of waivers in humanitarian applications. The reason is a lot of the humanitarian application types have some sort of waiver baked into it. So, for example, when I think of humanitarian applications, I'm thinking of domestic violence petitions, where
Hmm.
you would petition for yourself as the victim of domestic violence, or like a U visa, you would petition for yourself because you've been the victim of a violent crime, or a T visa, victim of trafficking. In those situations, if the reason for those things, you suffering the domestic violence or the crime or the trafficking, is what brought you into the US, then getting a grant of that visa or that status would automatically forgive your unlawful entry. So in that situation, you don't really need to worry about the waiver process. I think a situation where you might need a waiver would be if you were in if you were in removal proceedings. So, for example, the Department of Homeland Security discovered that you were here unlawfully and they initiated deportation proceedings against you. Now they're called removal proceedings. And you landed in court and you need to explain yourself in front of a judge. In that situation, the judge might entertain seeing a waiver application to see that if you're asking for the judge to terminate your proceedings, they want to see that there's some sort of plan. So they're not just releasing you back into the United States with no status where you're going to land right back in court again, but that you have a plan for getting lawful status. And maybe a waiver application would be involved in that. And so maybe the judge would want to see that you have a way to prove that you have the right to remain in the US, or if you had to go back out to come back in to create that lawful entry, you had a way of doing that. So that's where I could see there might be some overlap there.
Okay, awesome, and thank you. I think that's an extremely crucial point, especially in today's changing immigration climate. And speaking about change, many are wondering what shifts might happen when we see the change in administration, Attorney Liao. So basically, with the return of President Trump, what does this mean for the asylum policy and waivers?
Sure. I think what we can, so I live in San Diego, and I'm very close to the southern border. As you probably know, we have a border crisis where we have a ton of people flooding the southern border trying to come in that way. Very few of them actually have visas. The Biden administration had put different policies in place to try to limit the number of people that are able to get into the US or that are able to get status simply because the system is overwhelmed. And it's not just, it's not fair, but that's what they're trying to do. With the Trump administration, what we saw with the first Trump administration were different executive orders that Trump had signed to also do the same thing, to decrease the number of people who are coming in, to not overwhelm the system. With the second Trump administration, nobody can predict the future, right? Nobody knows exactly what's going to happen, but I would assume that his stance on immigration has not changed. The immigration bar, so me and all my colleagues, we're all
Mhm.
kind of, tightening our belts and we're like getting ready for a lot of litigation because any policies that you would try to generally apply to try to limit the number of people who come in for humanitarian reasons, for asylum reasons, there's inevitably going to be some constitutional violations with the implementation of those policies. So we're all getting ready to fight in court and appeal to
Mhm.
try to make sure that at least with the legislative machinery of our nation, the way that laws get made, the ways that policies get made, that there's at least a voice advocating on behalf of immigrants when constitutional violations occur. So the short answer to your question is we're expecting a lot harsher immigration policies, especially policies related to asylum and border control. Related to the humanitarian cases and waiver applications, um, I don't expect there to be very much change in terms of policy, but in terms of the way that those policies are implemented in the adjudication phase. What we experienced with the last Trump administration was the 601A waiver, which used to take, I want to say, like a year to process. At some point during the last Trump administration, that processing time lengthened to 5 years. And then during the Biden administration, there was a lawsuit that went in, basically saying that 5 year processing time is unreasonable. So that lawsuit won, and now I think the lawsuit won, but now the processing time is down to 3 years. I would expect under the second Trump administration that processing times for humanitarian visas, because that's not the priority of that administration, for the processing times to lengthen again. So not necessarily that the policy changes, but that
Mhm.
the resources allocated to processing those kinds of visas would probably not increase.
Awesome. And thank you again, once again, Attorney Liao, for your time so far. And thank you for joining us. If you're just tuning in on any social media platform, we have the honor of being joined today by Attorney Liao, a seasoned attorney who has done an amazing job for today's topic. This is immigrationquestion.com, a platform designed to make every immigrant's journey in the US easier. Ask your immigration questions for free in any language. You'll be connected to a verified attorney who can help you with any legal guidance. Even better, you can secure yourself a discreet and free initial consultation with immigrationquestion.com attorneys based on your discussion. Head over to www.immigrationquestion.com and sign up today. Before we go into our live Q&A, let's talk about the humanitarian parole. We're really seeing cases where people urgently need to enter the US but face significant barriers. In this situation, right, or I'll say, in what situation might the humanitarian parole come into play, and how does this differ from the waivers?
So humanitarian parole, when you use the word parole, the way that one of my colleagues explained it,
Mm,
it's kind of like you come into the US, but you're floating above the ground. And what that means is your body is here, but you don't have any legal status. Like
oh,
the US allowed you to come in, but
mm,
they're not allowing you to legally be recognized as having any status in the US. And the reason they
mm,
would do that is because you're physically in danger. So, for example, when the Russia Ukraine war happened in 2022 and Ukrainians began to come in through the southern border, they were coming in on humanitarian parole. They had no status, but they were at least safe and physically in the US, and then they could figure things out from there. The same was supposed to happen for our Afghan allies when the Taliban took over in 2021.
mm,
um, but I think what we've discovered is it wasn't enough for Afghans who were showing up at the southern border to be able to come in. Afghanistan had become such a dangerous place that their US based relatives were also submitting humanitarian parole applications or petitions to try to bring them over. So those are the two ways of doing it, right? Is if you need to come in urgently because you're in danger, or it doesn't matter at the moment that you don't have status, but you just need to physically come into the US, that can happen at the border and you can get paroled in. Or you could have someone submit a humanitarian parole petition for you while you're in another country, and then get a parole visa or travel document to be able to come into the US. So in
mm,
theory, according to the law, that's what happens. In practice, what happens is because the southern border is so flooded with people,
mm,
the number of people who can get processed for humanitarian parole have dramatically decreased, and they're a very small percentage of the actual number of people who are at the border and waiting to come in. There's this thing called the CBP1 app now that people know about that requires you, I think if you're within like 50 miles of the US border, you can download the app and request an
yeah,
appointment to come in. And CBP has their discretion to either parole you in, or what I'm seeing more, because I practice in San Diego, is they're actually detaining people and then forcing them to complete their arguing in front of a judge and trying to justify why they should get asylum, having them do that while they're detained.
mm,
What we've experienced with humanitarian parole from when you're outside of the US, especially with our Afghan clients, and right now there's actually pending litigation about this, is that the number of applications, the last time I checked, was well above 40 or 50,000. The number
Sure.
of approvals that were being issued were
Mm,
well under 500. And so there a lawsuit went in, which I think is, was very right, to argue that the
mm,
processing time for humanitarian parole from outside of the US is completely unreasonable. And
mm.
the approval rate is also unreasonable.
Although,
But so when you put in an application like that, where you're asking for parole for somebody from outside of the U.S., you have to justify that imminent danger aspect of things. So why is it that the U.S. government should allow them to bypass a normal visa process and give them this parole? Essentially, they're cutting the line to come in physically. You have to justify that. So yeah, the law says one thing, and there's a picture painted by what's possible under the law. In practice, because of the different crises that the U.S. government has decided to get involved with, and also the southern border crisis, in practice, it's just very challenging to get humanitarian
mm.
parole into the U.S.
Okay, amazing response. Ladies and gentlemen, the floor is now open for the Q&A. Please feel free to type your questions in the chat box. We will try to address as many as possible. If you want to call us live, ask your questions directly. The number to dial is 516-703-3483. So let's have first question is from Terry. I'm applying for a tourist visa, but was denied due to the intent to immigrate. Can a waiver help me overcome this?
That's a good question. In that situation, it cannot. So a waiver is if you've committed an immigration violation and you're asking for forgiveness. In this situation, you haven't violated anything, so you don't need forgiveness for anything. The consulate simply decided to deny your tourist visa, unfortunately. And that intent to immigrate reason is a very common reason for denial. So I would say the better use of and waiver applications are time consuming and expensive. I would say the better use of your resources and time would just be to renew the application and make sure to prove ties to your home country so that the consulate is convinced that you'll come back.
Thank you. Okay, next question is from Ifu. Do I need a lawyer to file a waiver application or can I do it myself?
You don't ever need a lawyer to do anything in immigration. If you feel fairly confident that you can research the law on your own and research the requirements on your own, have at it. More power to you. If for whatever reason you don't feel confident in your ability to do that research, or if you don't have the time, or if you have a very complex immigration history that needs a lot of explanation to show, despite all of these other violations, why you qualify for this waiver, in those situations, I would say hire an attorney. But you don't
Awesome.
need one, like technically. Yeah.
Right, from Jose, how long does the waiver process take and will it delay my visa application?
I think then my question would be what kind of visa you're applying for. So in most situations, waiver applications that I've seen, like the 601, the 601A, the 212,
Mm,
it usually accompanies an application for a green card, usually. Sometimes you can get it for an application for not a green card. If it's a green card situation and you're waiting for an immigrant visa, then I would say yes, it will delay your visa application because you need the waiver to be approved. You need the U.S. government to forgive your immigration violation to even be eligible to get your immigrant visa. Because if you step outside of the U.S. before your unlawful entry was forgiven, you're going to be barred for 10 years. Right. So I would say you got to wait for that visa to be approved, for especially a 601A to be approved before I would even tell my client to go out of the US, because otherwise it's too risky. If your waiver application is for a non-immigrant visa, then I would say probably also it will delay your visa application because you probably again need that waiver
mm.
to be approved before the consulate will give you anything. That would be my guess. But without knowing what kind of visa you're applying for, I can't say for sure.
Thank you. All right, so we got a question from Kim. If you're a DACA recipient, married for 5 years next month, applying for advanced parole, will I be allowed re-entry or will Trump administration stop the re-entry once he is in office?
We don't know where what you're doing is very wise. If you're a DACA recipient, get advance parole as soon as you can, and then create a lawful inspected entry for yourself so that you can adjust in the U.S. We don't know what he's going to do. His Nobody would be surprised if he took away advanced parole for DACA recipients, or if he tried to change the policy so that entry on advanced parole is no longer considered an inspected entry for the purpose of green card. We can't know, and we don't know where on his immigration list of priorities that would fall. What we do know is that his main priority seems to be the mass deportation of a lot of people. So, it's possible that taking away advanced parole from DACA recipients would fall very far down his priority list, and maybe he won't get to it immediately. But nobody would be surprised if he tried to do something like that.
Thank you, Attorney Liao. So next question is from Ameo. I overstayed my previous visa by 6 months. Can I apply for a waiver to return to the USA?
So if you overstayed by, so the number of days is very important. If you overstayed by 179 days or fewer, then you don't need a visa. It's only if you overstayed 180 days or more that you would need, that you would need a waiver. 100 days or more that you would need a waiver. And yes, so that's what I would say.
Awesome, thank you. Okay, so from Ahmed, I have a family member that is a US citizen. Will that increase my chances of getting a waiver, even if I have prior violations?
I think when you say a family member, in order to get approved for the 601 or the 212 waivers, that family member has to be a very specific family member. So it has to either be a spouse or a parent. I think with the 212, you might even be able to argue that children, US citizen children, might be able to qualify. I forget. Don't quote me on that. But it's not, does it increase your chances of getting a waiver? It's a requirement of you to get that waiver. If your US citizen family member is not a spouse, parent, or child, then no, it doesn't really increase your chance of getting approved for that waiver, unless okay, now I'm just being very hypothetical. Like, for example, if I was applying for a waiver and it was based on extreme hardship to my US citizen spouse, and let's say his US citizen mother or my US citizen mother, he was the main caregiver for the two of them, and I was helping him give care to the two of them. In that situation, yes, having a US citizen mother or having a US citizen or his US citizen mother would help with getting the waiver approved because he was their main caregiver. But the extreme hardship still has to fall on him, my US citizen spouse, for me to be able to get that waiver approved.
Awesome, thank you. Right, so from Florencia, if my waiver application is denied, can I apply again and get it?
It would depend on the reason for denial. If it was because you didn't provide enough supporting documents, then yeah, try again and provide more supporting documents. Or if circumstances have changed to where the qualifying relative that's experiencing the extreme hardship, suddenly their hardship became even more extreme, then yeah, I could see how you could just reapply. But if the reason for the denial is because you never qualified to begin with, like you were trying to waive an unforgivable, immigration offense, then I would say cut your losses, and you got denied for a reason that's you're not going to be able to overcome. So it's the reason for the denial, I would say.
Okay, awesome. And thank you once again for answering those questions. Well, that brings us to the end of today's session. Thank you for joining us. A special thank you to our guest speaker for sharing her time and expertise. We cannot wait to have you back on the show the next time. We hope the webinar answers some of the pressing questions on overcoming immigration barriers and understanding waiver applications. Visit our website at immigrationquestion.com to connect with experienced immigration attorneys who can guide you through the unique situations. If you have missed any part of the session and would love to listen again, this live stream is being recorded and will be live for your listening on Spotify. Simply search Borderless Talk by immigrationquestion.com and listen to today's session and previous ones on the go. Also, Join us once again in the movement at immigrationquestion.com's mobile app is up for download on both Google Play Store and Apple Store. You can now ask your questions on the go, claim leads as an attorney, and maintain engagement on the community forum. Amazing, right? So download it now. The experience is magic. So to each single one of you for joining us in today's session. We will definitely see you at the same time, same place, same platform. Once again, thank you for being here to in today's session, Attorney Liao. It's indeed been an insightful session, and all thanks